Okay, we'll call the hearing back to order, and Mr. Burgess.
Mr. Chairman, SC calls Iris Griffin and Angela Nagy to the stand.
Y'all will punch the little button and make the little red light come on. You'll be, and make sure you're on. Everybody, you're off. You need to punch it again. You're on. Okay, just make sure you talk into that microphone.
Mr. Chairman, I'll start with Ms. Griffin. Would you please state your full name for the record?
Iris Nicole Griffin.
And by whom are you employed and in what capacity?
I am CFO and Treasurer for SCANA.
And have you prepared or caused to be prepared under your direct supervision and pre-filed in this docket direct testimony consisting of 57 pages?
I have.
And Mr. Chairman, just for clarity, I'm asking Ms. Griffin about the pre-filed direct testimony she filed in docket 2017-370-E. Ms. Griffin, are there any changes or corrections required of your pre-filed direct testimony?
There are.
Would you please direct the parties and the commissioners to the page number and line number where that correction is required?
Okay. On page 55, line 16, the $38 million amount that's referenced should be $24 million.
And are there any other changes or corrections required of your pre-filed direct testimony?
No, they're not.
And with those corrections, if I ask you the same questions contained in your pre-filed direct testimony, would your answers be the same?
They would.
Mr. Chairman, at this time, we would move into the record the corrected pre-filed direct testimony of Iris Griffin, which was pre-filed in docket number 2017-370-E, and ask that that be given orally from the stand.
Ms. Griffin's pre-filed direct testimony in docket 217-370-E will be entered into the record as though given orally from the stand.
Ms. Griffin, are there any exhibits attached to your pre-filed direct testimony?
There are.
And do you have any changes or corrections required of those exhibits?
I do not.
Mr. Chairman, we now move into the record the exhibits attached to Ms. Griffin's direct testimony. Those are identified as ING-1 through 4, and we ask that those exhibits be marked as the next hearing composite exhibit.
Okay, Ms. Griffin's exhibits ING 1 through 4 will be entered into the record as exhibit number 84.
Thank you, Mr. Chairman. Ms. Griffin, I'm going to move to your rebuttal testimony filed in docket 370-E. Have you also prepared or caused to be prepared under your direct supervision and pre-filed in this docket rebuttal testimony consisting of 28 pages?
I have.
And are there any changes or corrections that you would like to make to your pre-filed rebuttal testimony?
Yes, there's one change.
All right, would you please direct us where that page number is and the line number?
Page 26, line 1, we should strike most recent 12-month test period and replace that with 12 months ended December 31st, 2017.
Are there any other changes or corrections required of your pre-filed rebuttal testimony?
There are not.
And with those corrections you just described, if I ask you the questions contained in your pre-filed rebuttal testimony, would your answers be the same?
They would.
Mr. Chairman, at this time we would move into the record the corrected pre-filed rebuttal testimony of Iris Griffin submitted in docket number 2017-370-E as if given orally from the stand.
Ms. Griffin's corrected pre-filed rebuttal testimony in 2017-370-E will be read into the record as if given orally from the stand.
Ms. Griffin, do you have any exhibits attached to your rebuttal testimony?
I do.
Are there any changes or corrections that you'd like to make to your exhibits attached to that testimony?
No, there are none.
Mr. Chairman, we would move into the record the exhibits attached to Ms. Griffin's rebuttal testimony, which was identified as ING-1A and ING-2A, and ask that these exhibits be marked and entered as the next hearing composite exhibit.
Ms. Griffin's rebuttal exhibits ING 1A and 2A will be entered into the record as exhibit number 85.
All right, Ms. Griffin, I'm now going to turn to docket 270E and docket 305E. Did you prepare or cause to be prepared under your direct supervision and pre-filed in these dockets direct testimony consisting of 10 pages?
I did.
And do you have any changes or corrections required of that testimony?
I do.
Would you please direct the commissioners and the other parties of record to where that change is required?
On page 5, line 5, we should strike ORSs and replace with FOE/Sierra Clubs.
Ms. Griffin, are there any other changes or corrections required of your pre-filed direct testimony?
There are not.
And with the change you just described, if I ask you all the questions contained in your pre-filed direct testimony, would your answers be the same?
They would.
Mr. Chairman, we would move into the record the corrected pre-filed direct testimony of Iris Griffin, which was submitted in docket 2017-207-E as well as 2017-305E as if given orally from the stand.
Okay, Ms. Griffin's pre-filed direct in testimony in 2017-207E and 2017-305E will be entered into the record as though given orally from the stand.
Ms. Griffin, do you have any exhibits attached to your direct testimony in those dockets?
I do not.
Mr. Chairman, at this time, we would move into the record the exhibits attached to Ms. Griffin's direct testimony, which has been identified as ING-1A through 8A, and ask that those exhibits be entered as the next hearing composite exhibit.
Okay, they will be entered as exhibit number 86, and that's the ING 1A through 8A.
Thank you, Mr. Chairman. We're getting there, Ms. Griffin. I promise. We're almost done. Have you also prepared or caused to be prepared under your direct supervision and pre-filed in these dockets sir rebuttal testimony consisting of 2 pages?
Yes.
And are there any changes or corrections you'd like to make to your sir rebuttal testimony?
No.
And if I ask you all the questions contained in your sir rebuttal testimony, would your answers be the same?
Yes, they would.
Mr. Chairman, at this time, we would move into the record the pre-filed sir rebuttal testimony of Iris Griffin submitted in dockets number 2017-207-E and also 2017-305E as if given orally from the stand.
Ms. Griffin's sir rebuttal testimony in 2017-207E and 2017-305E will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. Do you have any exhibits, Ms. Griffin, attached to your sir rebuttal testimony?
I do.
Are there any changes or corrections required of your exhibit?
There is one.
Okay. If you'll direct us to where that change is required.
Page 26 of that exhibit, line 1, strike most recent 12-month test period and replace with 12 months ended December 31st, 2017.
Any other changes required of that exhibit?
No.
Mr. Chairman, we would move into the record the corrected exhibit attached to Ms. Griffin's sir rebuttal testimony identified as ING-1 and ask that that corrected exhibit be included as the next hearing composite exhibit.
Ms. Griffin's sir rebuttal exhibit ING-1 will be entered as exhibit number 87.
Okay, Ms. Griffin, have you prepared a summary of your testimonies?
I have.
Would you deliver that at this time? And then when you're finished, I'll then turn my attention to Ms. Nagy.
Good afternoon, Chairman Randall and members of the Commission. My testimony first provides an overview of the company's financial position. It discusses the primary regulatory plans set forth in SCE&G's and Dominion Energy's joint petition. I also discuss a number of detailed issues related to tax and accounting matters. My pre-filed testimony is quite extensive, so in this presentation I'm summarizing only certain points. I am happy to answer questions about any of the matters that I do not mention here. As SCE&G's CFO, my primary focus is the company's financial health and stability. I'm responsible for making sure SCE&G has the cash it needs to fund its day-to-day operations and maintain its electric and gas systems. Currently, the long-term financial health of SCE&G is in question. Rating agencies and investors are watching these proceedings closely to ascertain information about the future of the company. Based on regulatory and political uncertainty and temporary rate reductions, SCE&G has already taken over $1 billion of write-downs and been downgraded to junk status by one rating agency. SCE&G has limited access to the daily commercial paper market and is paying a much higher premium today for short and long-term capital than its peers. If the rate proposal by ORS is accepted, a total write-down of approximately $2.5 billion would be triggered. Additionally, Dominion Energy has said it will not proceed with the merger under these circumstances, so the potential credit support the combination offers would vanish. Rating agencies indicate that they may further downgrade SCE&G's debt ratings. The consequences of these events would further strain SCE&G's financial integrity. SCE&G's 700,000 electric customers and 300,000 natural gas customers deserve a reliable utility that's financially stable and able to invest in new technologies. A proposal that would further impair SCE&G's financial integrity unnecessarily puts the cost and quality of future service to customers at risk. As I explained in my testimony, SCE&G must invest approximately $500 million in additional capital in its system each year to maintain safe and reliable service. This $500 million represents the cost of replacing worn-out or obsolete equipment, extending service to new customers, expanding generation and transmission capacity, and meeting changing regulatory and system security mandates. Week to week, month to month, SCE&G needs both rate revenues and access to capital markets to have cash to pay its payroll and fund its operations. The credit rating agencies based a portion of their rating on qualitative factors such as regulatory environment and cost recovery. They also base a large portion of the rating on financial metrics. Although SCE&G's current financial metrics are in the investment grade range, SCE&G is still rated at junk status with Fitch, due largely to the qualitative aspects of the rating. If the ORS plan were adopted, the company has calculated the metrics and determined that they would likely fall below the investment grade range. This puts SCE&G in danger of being rated as junk status at more than one rating agency. SCE&G has already experienced financial consequences from the uncertainty surrounding the recovery of the new nuclear project and the uncertainty surrounding the merger with Dominion Energy. We've experienced difficulty in placing commercial paper in the short-term commercial paper markets. We've been required to post collateral with suppliers due to our credit status. Our most recent long-term bond issuances required us to offer a risk premium that was 80% higher than utility companies without our credit challenges. These events increase our cost of providing service to customers. The Commission has been presented with several plans for rate recovery of the nuclear project. We believe the Commission approving the Customer Benefits Plan to be the best case for customers and the companies. This will clear the way for the Dominion Energy merger, allowing rate reduction for customers and a financially healthy utility that can invest in infrastructure for the citizens of South Carolina and that can help continue to support the economic development activities that have benefited our state in recent years. In my testimony, I provide a calculation of SCE&G's financial returns for the three regulatory plans presented in the joint application for a plan that would make the Act 258 reductions permanent, and in my rebuttal testimony for the plan proposed by ORS. In addition to these plans, Dominion Energy has presented an alternative plan that focuses on lowering rates as opposed to providing a one-time cash benefit to customers. As detailed in my testimony, if the Customer Benefits Plan had been in effect during the 12 months ended December 31st, 2017, SCE&G would have earned a return on equity of 8.83%, which is 142 basis points lower than its allowed return of 10.25% as established in Order Number 2012-951. But this 8.83% return is achieved only after SCE&G has written off approximately $2.8 billion in assets. This means that in addition to the 8.83% return on remaining assets, SCE&G's investors, Dominion Energy in this case, will not earn a return on or receive any recovery of $2.8 billion in assets going forward. As a disfavored alternative to the Customer Benefits Plan, SCE&G has proposed the No Merger Benefits Plan, which involves no cash payments to customers, a lower total rate reduction, and recovery of the balance of the VC Summer nuclear project investment over 50 years rather than 20 years as provided for in the Customer Benefits Plan. Under the No Merger Benefit Plan, SCE&G would earn a return on equity of 8.53%, which is 172 basis points lower than its allowed return of 10.25%. This plan requires SC&G to write off approximately $1.1 billion in assets on which SC&G's investors will not earn a future return on or receive any recovery of. Under the ORS plan, SC&G would earn a return on equity of 7.66%, which is 259 basis points lower than its allowed return of 10.25%. This plan requires SC&G to write off approximately $2.5 billion in assets. A write-off at this level as a standalone entity would fundamentally weaken SC&G's balance sheet. Furthermore, Dominion Energy has clearly indicated that adoption of the ORS plan would cause the merger to fail, which would be a significant negative factor as the rating agencies evaluated the company's credit. My testimony also discusses the monetization of Toshiba corporate guarantee settlement payments, certain accounting issues, and the appropriate rate treatment of savings associated with the Tax Cuts and Jobs Act. I also discuss a number of accounting adjustments and other tax matters at issue in this proceeding. In conclusion, my request to the Commission is that it approve the customer benefits plan and the business combination with Dominion Energy that makes it possible. This proposal seeks to balance the sharing of responsibility for the VC Summer project between shareholders and customers. The approval of this plan and the merger with Dominion Energy will provide the customers of SCE&G with a financially stable utility that's able to provide reliable service and invest in the future of South Carolina. For those reasons, I respectfully request that the Commission approve the customer benefits plan. This concludes my summary.
Thank you, Ms. Griffin. I'll now turn to Ms. Nagy. Would you please state your full name for the record?
Angela Marie Nagy.
And by whom are you employed and in what capacity?
I'm employed by Ernst & Young LLP and as an executive director.
And have you prepared or caused to be prepared under your direct supervision and pre-filed in this docket, which is 2017-370-E, rebuttal testimony consisting of 11 pages?
I have.
And are there any changes or corrections that you would like to make to your pre-filed rebuttal testimony?
Yes, there is one.
All right. Well, if you'll direct the commissioners and the other parties of record to where that change is required.
On line 9 of page 6, on page 9 of line 16, ORS should be replaced with commission.
All right. Are there any other changes or corrections required of your rebuttal testimony?
No, there are not.
And with the correction that you just described, if I ask you the same questions contained in your rebuttal testimony, would your answers be the same?
Yes, they would.
Mr. Chairman, at this time, we would move into the record the corrected pre-filed rebuttal testimony of Angela Nagy as if given orally from the stand.
Ms. Nagy's pre-filed corrected rebuttal testimony will be entered into the record as though given orally from the stand.
Thank you, Mr. Chairman. Ms. Nagy, did you also prepare or cause to be prepared under your direct supervision and pre-filed in docket number 2017-270E and 305E rebuttal testimony consisting of 2 pages?
Yes, I did.
And are there any changes or corrections required of your pre-filed rebuttal testimony?
Yes, there is one.
Okay, if you'll direct the commissioners and the other parties of record to where that change is required.
That change is on page 9, line 16, replacing ORS with commission. There are no other changes.
Is that in your exhibit?
Yes, sir. I apologize. That was in the exhibit. There
Okay.
are no changes to the actual rebuttal testimony.
Okay, let's just make sure that's clear. All right, so no changes are required of your pre-filed rebuttal testimony.
That is correct.
Okay, thank you, Ms. Nagy. At this time, we would move into the record the pre-filed rebuttal testimony of Angela Nagy in dockets number 2017-270E and 2017-305E as if given orally from the stand.
Okay, Ms. Nagy's pre-filed rebuttal testimony in 2017-207E and 2017-305E will be read into the record as though given orally from the stand.
Thank you, Mr. Chairman. And Ms. Nagy, did you also have exhibits attached to your rebuttal testimony?
Yes, I had one exhibit.
Okay, and do you have any changes or corrections required of that exhibit?
Yes, I'm eager to make that change.
Please do. We've been waiting.
In the exhibit to my rebuttal testimony, there is one change. That change is on page 9, line 16. And on that exhibit, we need to please strike ORS and replace that with commission.
Okay, great. Thank you, Ms. Nagy. Mr. Chairman, we would now move into the record the corrected exhibit attached to Ms. Nagy's rebuttal testimony, which was identified as AN-1, and ask that that be marked and entered as the next hearing exhibit.
Okay, Ms. Nagy's corrected rebuttal exhibit marked AN-1 will be entered as exhibit number 88.
Thank you, Mr. Chairman. Ms. Nagy, have you prepared a summary of your testimonies?
I have.
Would you please deliver that at this time?
Yes, thank you. Chairman Randall and members of the Commission, good afternoon. My name is Angela Nagy, and I'm employed as an executive director at Ernst & Young. I'm a certified public accountant licensed in Georgia. Over the last 20 years, I have worked with multiple electric, water, and gas utilities on accounting matters and have served as a public company controller of a utility that merged and integrated another utility. I am here today to provide rebuttal testimony to accounting assumptions reflected in ORS testimony, specifically of Lane Collin and other interveners in these dockets. SC&G has requested to recover costs incurred in periods through September 30th of 2017. Mr. Collin claims that because certain of these costs were not paid before September 30th of 2017, these costs cannot be recovered. Mr. Collins' proposed treatments of certain amounts in the ORS plan is inconsistent with the definition of incurred as it applied in generally accepted accounting principles in the United States. I would ask that the Commission recognize that SCE&G's request to recover costs incurred in periods through September 30th of 2017, even if certain amounts were not yet paid by that date, is consistent with generally accepted accounting principles. It is a basic concept of accounting that costs are matched to the period in which they are incurred rather than when they are paid. This means that SCE&G may seek recovery for costs related to periods on or before September 30th of 2017, even if paid after September 30, 2017. Regardless of when they became known or finalized, as long as these costs were related to work performed or products and services received on or before September 30 of 2017. The same principle and reasoning applies to any sales and use taxes related to the period prior to September 30th of 2017. If the company ultimately is found to owe additional sales and use taxes, these amounts would also represent costs incurred for the N&D project for the period to which the related purchases occurred, even though such tax amounts would be remitted in a later period. Again, under the matching principle, the sales taxes would properly relate to the same period as the related purchases and meet the definition of having been incurred in that period, regardless of when such amounts were paid. Mr. Collin also does not support the request of SC&G to be allowed to satisfy an estimated $85 million reduction in the Toshiba proceeds regulatory liability under the No Merger Benefit Plan. I disagree and ask the Commission to recognize that it would be appropriate for SCE&G to net any future payments to satisfy outstanding liens associated with the N&D project from the proceeds of the Toshiba parental guarantee. The $85 million reflects SCE&G's estimate of potential payment obligations to satisfy contractor liens filed after the Westinghouse bankruptcy. Such liens, to the extent determined to be valid claims and related to costs that were incurred prior to the cessation of the work on the project or during the early wind-down period, should be valid. If the company is required to make payments to satisfy these contractor liens, then any such amounts should reasonably be considered as a reduction in the Toshiba proceeds regulatory liability. Another issue related to the Toshiba proceeds regulatory liability is Mr. Collins' recommendation that the regulatory liability should earn a return. My understanding is that a large portion of the cost of the nuclear project costs, which are directly related to the Toshiba parental guarantee proceeds, is not currently earning a return or subject to financing cost recovery in the form of revised rates. This is particularly true after the imposition of Act 258 experimental rates retroactive to April of 2018. In the absence of finance cost recovery or an additional facilities charge rider with respect to these costs, the company should not be penalized by providing a return on the regulatory liability while not allowed to receive a return on the related nuclear project costs. The treatment should be symmetrical. Thus, if the related nuclear project costs were earning a return, then it would be appropriate for the regulatory liability related to the Toshiba proceeds to also accrue a return. Again, my point is that they should be consistently treated. Next, I ask the Commission to recognize that the assumptions used by Mr. Collin to calculate the rate-based tax impact of the TCGA are not sufficient to rely upon in this proceeding. Mr. Collin makes unreasonable assumptions related to revenue growth. Mr. Collin's assumption that taxable income varies solely with changes in kilowatt-hour sales is overly simplistic. While revenue is certainly a component in the determination of taxable income, aspects related to operating expenses, gains and losses, and other factors together create the taxable income, the resulting taxable income. Further, it is not reasonable to assume 2011 data simply escalated to 2018 is an accurate indicator of 2018 results. Last, Mr. Collins' suggestion that the transmission revenue requirement of the BLRA should be deferred does not consider the potential accounting impacts that may result from the proposed deferral. Depending on the specifics of any potential Commission order, an additional impairment could arise from the requirement for SCE&G to defer consideration of recovery of these transmission costs. Mr. Collins' approach adds more uncertainty to the analysis with respect to eventual future recovery of these transmission costs. This uncertainty increases the likelihood that an impairment with respect to these costs, respect to these assets, may be required to be recognized in SCE&G's financial statements. This concludes my summary.
Thank you, Ms. Nagy. Mr. Chairman, these witnesses are available for questioning by the parties as well as the commissioners.
Thank you. Mr. Guile.
Thank you, Mr. Chairman. I have no questions for these witnesses.
Okay. Mr. Richardson.
Thank you very much, Mr. Chairman. For clarification, Mr. Chairman, I will only be questioning Ms. Griffin. My colleague, Mr. Nelson, will be questioning Ms. Nagy. Good afternoon, Ms. Griffin.
Good afternoon.
So you agree that South Carolina Electric and Gas has the ultimate responsibility to the ratepayers and to this commission for the VC Summer Units 2 and 3 project, don't you?
I do agree with that.
And that SCE&G chose to hire Westinghouse and the consortium under the EPC contract.
Yes.
And that only the utility comes to the commission for approval of the budget and the schedule and cost recovery for the project, right?
As opposed to Westinghouse, is that
right?
Yeah.
Not the commission. I mean, excuse me, not the consortium or anybody else that SCE&G hired to build the project.
That's correct.
And you agree with me, wouldn't you, that SCE&G is supposed to be completely transparent and honest in coming to the commission for approval of the construction schedule and budget, don't you?
I do agree with that.
And as a CPA and a CFO of SCANA, you know that the omission of material facts is false and misleading, don't you?
Yes.
And you agree that SCE&G is not blaming the commission or ORS for failing in the project?
That's right. I think we've been clear that our blame really is on Westinghouse.
Okay. And you gave sworn testimony in several forms in the federal court action this summer, right? But when SCE&G challenged the experimental rate?
That's correct.
And ORS pre-filed the transcript of the cross-examination of you under oath in court as part of the pre-filed testimony in this case. Do you remember that?
I do.
And you also presented in that matter a sworn declaration and verified the complaint that was filed in federal court, didn't you?
That's correct.
Could you verify for the commission that testimony, both written and oral, given in the federal court case, is true and accurate, and the answers that you would give today if you were asked those questions again?
Yes, I mean, obviously they were given a bit ago, but those were accurate at the time I was given those statements, yes.
Thank you. And Mr. Chairman, we would move for the admission of the testimony from the federal court hearing that we submitted as pre-filed testimony from Ms. Griffin as if it were read out loud from the witness stand and into the record.
Okay, Ms. Griffin's testimony given in federal court will be read into the record as if given orally from the stand.
The ones that we pre-filed. The
pre-filed.
We have two exhibits that we just addressed, the declaration signed by Ms. Griffin and also the verified complaint in the federal court action that we're submitting as the next two hearing exhibits.
Mr. Chairman, if I may be addressed, and just for clarity, I do believe that ORS did not pre-file the entire transcript with respect to Ms. Griffin's testimony before the federal court action. So I would simply request that to the extent that they are going to rely upon that testimony, that this commission be provided with the full record from that proceeding, and ask that Ms. Griffin's entire testimony from the federal court action be moved into this record as a given orally.
Okay, we'll put all of Ms. Griffin's pre-filed, her testimony from the federal court hearing as if given orally from the stand. Okay, now we've got these. What do we need? Okay, can we get a copy of that furnished just to make sure?
Yes, sir.
Commissioner Elam was asking for that.
We'll go back and see which pages they selected, and we'll fill in the voids.
Okay, thank you. Okay, now we've got exhibits that we need to enter, right? Okay, so we'll do the verified complaint will be exhibit number 89, and the declaration will be exhibit number 90.
Thank you, Mr. Chairman.
Mr. Chairman, if I could have a piece of clarification. Michael Anzola for the speaker. Are we also including Ms. Griffin's cross-examination and everything? I didn't quite hear what Chad was asking to be introduced.
Sure. Well, Ms. Griffin was subjected to extensive questioning at the federal court action, and my request is simply that if we're going to rely upon a piece of that transcript from which she was being questioned, that this commission should be provided the complete line of questioning that she was subjected to during that proceeding.
Yep, that's fine as long as it includes our cross as well.
We'll include the cross as well.
And that was part of the pre-filed testimony, Mr. Chairman.
Okay, we've got everything in now that we need. Okay, good.
Ms. Griffin, the Base Load Review Act only authorizes SC&G to recover its capital cost if it acted prudently. Isn't that right?
That's right. We're able to earn a return on our investment during construction. And then upon abandonment, we're now seeking recovery of that capital investment as well.
Right, but only to the extent that it was incurred prudently, right?
That's correct.
And SC&G to recover its financing costs during the construction through revised rates had to be prudent about incurring those costs, including staying within an 18-month window of the approved schedule, right?
That is my understanding, yes.
And this is a little different than I asked before, but it sounds similar. SC&G was supposed to be completely honest and transparent in seeking the recovery of those financing costs during the construction through revised rates every year. Isn't that right?
That's correct.
And we talked about this in federal court too, but when SC&G abandoned the project on July 31, 2017, it's obvious SC&G was no longer constructing the units within the parameters of the approved construction schedule and budget, were they?
That's right. The units were no longer under construction.
And when SC&G is no longer constructing units within the parameters of the approved schedule and budget, that means SC&G no longer meets the condition required under the Baseload Review Act to continue collecting financing costs.
Objection.
Isn't that right?
He's calling for a legal conclusion.
Sustained.
Thank you. We'll see it in your pre-file testimony in a minute anyway. You're familiar with SC&G's internal analysis in April and May of 2017 that found that the time to completion was more than 2 years beyond the approved schedule?
Yes, after we found out that Westinghouse was declaring bankruptcy, we completed an internal analysis. That was, yes, around that time, April through July.
And that analysis found that the time to complete the project at that point was more than 2 years past the approved schedule, right?
That's my recollection, yes.
And do you also remember that analysis concluded that the cost to completion at that point was an additional $2.5 billion?
I agree with approximately that number. Yeah, I don't remember the number off the top of my head.
Okay. And SC&G didn't come back to the commission to modify the schedule or the budget, even after confirming that the project was outside the parameters of the approved schedule and budget, did it?
That's right. I believe we made a filing, an abandonment filing with the commission at that time.
Right. So there's no dispute that the day before abandonment, SC&G was not constructing the units within the parameters of the approved schedule and budget, was it?
The day before abandonment. I think that would be true based on the analysis we had completed at that point.
Okay. Now, do you know how much SC&G collected from ratepayers in revised rates since abandonment?
I don't have that number.
Okay. And let's include what will be collected through December of 2018. Mm-hmm. August 1st, 2017 to December 31, 2018. Does $350 million sound about right?
That seems like it may be a little high since we've had Act 258 in place.
Okay, well, let's talk about it then. I'm sorry I don't have a board to do the math on it, but I think it's fairly straightforward. We know that the total revised rates, right, the full amount of revised rates through 2016, the last revised rate order, was $445 million a year, right?
That's correct.
And then in August through March of 2018, that's 8 months, right? Mm-hmm. The full amount was being recovered.
Correct.
Right? Okay, and so I had to do the math on my calculator, but that would result in $296 million. Is that, you have any reason to dispute that?
I don't have any reason to dispute that.
You have a calculator?
I do not have a calculator.
So after March, we had the experimental rate was effectively in effect, and the revised rates under the experimental rate was the $445 million in total minus $367 million on an annualized basis, right?
That's correct.
Right. So that yields $78 million, and we've talked about the $78 million is the experimental rate of NND cost recovery.
Yes.
And so 9 months of that, April through December, is approximately $58.5 million.
Seems appropriate.
All right, and the total of that would be $354 million.
Yes.
All right. And if SCE&G should not have continued collecting financing costs as revised rates after abandonment, it would owe a regulatory liability to ratepayers of that amount, wouldn't it?
If I'm to assume you're hypothetical, then yes, that would be the case.
Okay. And SC&G says that it will reduce revised rates by only $413 million a year instead of the full $445 million, right?
I think what we've done is we've implemented Act 258 at this point. But yeah, the difference between the 445 and the 413 is the transmission assets.
Right. And that's what I was getting to. The other $32 million that SC&G is asking the commission to allow it to continue collecting out of revised rates at this point and after this permanent rate is set are the financing costs for the transmission costs, right?
That's right.
And those transmission costs themselves, though, even SC&G and Dominion are asking for those to be deferred to the next general base rate case, right?
Well, what we're asking for in our application is that we continue to collect the amount that's currently in rates, but there's a portion of the transmission assets that are not yet in rates. And then there's also depreciation and operating costs on those transmission assets that are in service. And we're offering to defer those, but we would like to leave the amount that's currently in rates in rates.
Right, and obviously, you know, our ORS is saying you should be protected, but defer all of those to the next general base rate case because they're not N&D assets that are abandoned, right?
That's right. I think ORS is proposing to remove all transmission from rates currently.
And just to defer it until the next general rate base case, right?
That's my understanding.
Right. And instead, SC&G is saying, let us keep collecting the financing costs for those investments.
That's right. We're saying those investments are used and useful. They're providing a benefit to our customers, and so we would like to continue collecting those.
And that amount of revenue that the joint applicants are asking for would be put into the capital cost rider, which would become part of the N&D recovery for the next 20 years, right?
That's right.
So what happens to the financing costs on these investments when the next general rate base comes and those amounts are put into the general base rate?
That, you know, if you're talking about the Dominion proposal with the capital cost rider, their witnesses would probably be better served to address that. But my understanding is that would all be dealt with as part of a general case. But I'd prefer for them to answer those details.
Okay. And these consolidated dockets, let's talk about the issues in this case. There are three major issues, right? We've heard about N&D cost recovery, right? The savings from the Tax Cut Jobs Act. And then the merger and its conditions, right? Three.
Right.
And do you agree that the amount of N&D cost recovery for the abandoned project really has four components? The amount of allowed costs, the adjustments for regulatory liabilities, the rate of return, and the amortization period.
Yes.
Okay, and there are more details, obviously, but that's the components. And do you agree for the second issue about the Tax Cut Jobs Act that all savings should be passed on to ratepayers and that it's unrelated to the N&D costs?
Yes, the savings from the Tax Cuts and Jobs Act should be passed to our customers.
And it's unrelated to the N&D costs.
We're dealing with those in our North Carolina jurisdiction as well as our gas business here. So that's not unique to this situation.
And it applies to every utility in South Carolina, too.
That's right.
And further, that the Tax Cut Jobs Act savings is in this proceeding because SC&G asked for it to be, isn't that right?
That's correct.
Okay. And then the merger approval, or at least for the commission not to reject it as being against the public interest, requires some conditions that both have been proposed by the joint applicants and by interveners and ORS to protect the ratepayers and the public's interest, right?
That's my understanding.
All right. Did I leave anything else out about the overview of the issues in this case?
Not that I can think of off the top of my head.
Me either. Thank you.
Yeah.
And putting aside the merger conditions and the merger itself, there's really two adjustments being made to the rates in this proceeding. The N&D recovery from ratepayers, if any, beyond the $2.2 billion that's already been collected, right?
Correct.
And two is to pass to the ratepayers all of the savings from the Tax Cut Jobs Act, right?
That's right.
All right. Let's think about, I want to talk a little bit about some of your testimony that deals with the overall financial health of the utility and the entire rate structure of the utility. SC&G did not file its petition for recovery of abandonment costs by asking the commission to come in and determine like the entire rate structure and the overall rate of return for SC&G as a whole, did it?
No, we did not file a base rate case, no.
And so SC&G is not telling the commission that those two changes that we talked about, the N&D costs and the Tax Cut Jobs Act savings, require a determination of the entire rate structure and the overall rate of return for the company. Does it?
That is correct.
Okay. And we've heard some suggestions from SC&G in this case that ORS should have evaluated the overall financial health of the utility. And your rebuttal testimony, pages 4 and 5, specifically address that. Do you remember that?
I do.
All right. But SC&G is not trying to tell the commission that it has to accept the rate of return from the past revised rate orders that were being used when the project was being constructed.
I'm sorry, could you repeat that?
Yeah, I mean, you're not saying that the commission has to accept the previously established rate of return under the revised rate orders, are you?
Our position is that the revised rates that were put into place over the course of time were reviewed at the time they were put in effect. And I can't speak legally to the commission's ability to go back and retroactively change that.
No problem. And y'all, of course, are asking for the 10.25 to be continued for the abandoned cost. But you even brought an expert in, right, that talked about a range of option of rates of return. And so you're not saying that the rate of return that the commission is required to find that rate is the only rate of return.
No, we're not. And I think even in Dominion Energy's alternative plan, they've proposed a rate that's lower than that. I believe they proposed 9.9%.
Right. Thank you. Mm-hmm. So I want to look at your rebuttal testimony on page 5, lines 3 through 8.
Okay.
And you see this is, it refers back to some prior investment in transmission and certain generation projects, but it says that the SCNG believes the cost of capital associated with these amounts, and that's the transmission projects and the certain generation projects, as well as depreciation expense and operating costs, should be considered in determining the revenue requirements, setting rates, and evaluating the rate proposals being made in this docket under a code section 58-27-870F.
Yes.
And we've already talked about deferring the transmission and these other costs to the next general base rate because they're not being abandoned. But do you know why this code section was cited in your testimony?
Unfortunately, I do. I had to go read these before they were put in here. And what that 58-27-870F relates to is that the PSC puts rates in place without notice or hearing when they don't require determination or don't require a rate increase.
All right. But that code section doesn't require the consideration of the investment assets that SCNG is now saying is going to be deferred to the next general base rate case, does it?
No, we're not asking the commission to rule on anything at this point that we're planning to defer. We were just asking that rates be left in place for the transmission that's used and useful.
All right. And in fact, I think you just said it, but the code section allows the commission to set rates without considering the entire rate structure and rate of return for the company, right?
That's correct.
Okay. Does this code section prohibit the commission from changing the rate of return on NND costs? Or...
I don't know that I could speak to that.
Okay. But SCNG's, I guess I should ask, I mean, I can't understand why this statute even applies. Do you know why it might even applies in this case?
Well, I think because we're asking for the commission to set rates under the statute, and I'm going to get well outside of my bounds if I try to interpret this legally, but my understanding is that the commission can take rate action in these circumstances, and we feel like our situation fits into these circumstances.
This hearing would fit into circumstances that allow the commission to, without notice or a hearing, to put in rates that don't require...
Yeah, we're not asking for a rate increase in this case before the commission.
Okay. Are you familiar with Act 258 and Resolution 287 that repealed the BLRA and extended the time for this hearing and defined prudent and other things?
I am.
Right. Did you know that that act added a code section 58-34-40 that says any provision of Chapter 27, Title 58 in conflict with the provisions of this chapter, including but not limited to the one we just cited, 870, is suspended for purposes of utility rates provided for by this chapter and for any pending matters related to the VC summer under a final determinations matter?
I am not familiar with that.
Does that at least look like that 58-27-870 has been suspended for pending matters related to this commission's determination in this case?
Objection. That calls for a legal conclusion.
Sustained.
Thank you, Mr. Chairman. Do you remember when SCNG's lawyers and some of the witnesses have criticized ORS for failing to analyze the SCNG's overall financial condition?
I don't remember any specific criticism, but I do know there's been a lot of discussion of that over the last several days.
And when was the last base rate case by SC&G?
I believe that was in 2011.
And SC&G, that was a test year. It was in 2012.
2012, you're right.
And the SC&G hasn't sought to increase or change the base rate since 2012, has it?
That's correct. We've actually been intentional about trying to avoid a base rate increase because we knew we had nuclear rate increases going into place.
Right. You're relying on the revenue from the revised rates to carry the company, even though you're making $500 million of investments every single year.
No, it wasn't so much that. It was just we knew that it was challenging to continue to increase our rates annually and was challenging for our customers. So we didn't want to double dip, if you will, and add another base rate case on top of a nuclear rate case.
Right. And coming to the commission and getting revised rates was really easy, wasn't it?
I don't know if I would say it was easy, but we made cuts and held constraints in place at the base business to try to avoid rate cases.
You still spent well over $1 billion since 2012 that you're not recovering from ratepayers, isn't that right?
If you look at it on a gross basis, that's true. If you really look at the net change in rate base, I think it's only about $300 million since that time.
And so SC&G's decision not to even seek a base rate case in more than 5 years, that's contributed to the weakened financial condition of the company, hasn't it?
Certainly that could play into this, yeah.
Okay. And there are other management decisions, right, that have affected SC&G's overall financial condition, right? And I want to run through some and just tell me if you agree with these management decisions having affected the overall financial condition of SC&G or SCANA. The first one is essentially the project, but spend billions of dollars on a failed project, right? That would have affected the financial.
Yes, spending billions of dollars on the project and it not being finished has definitely had an impact.
And SC&G never hired an owner's engineer to oversee the project day to day?
I don't know that I know enough about construction to weigh in on that.
How about ignoring the internal EAC review team?
Again, I don't have any personal knowledge of that.
And how about hiding the Bechtel reports?
I have no knowledge of that either.
How about thinking that it was possible to shift billions of dollars of cost to Westinghouse under the EPC amendment without real protection against those risks?
I wasn't involved in those decisions either.
Okay. How about, you know about the payments made to Westinghouse, right? The $100 million a month for 8 months in 2016 without any construction milestones being met?
I've heard those discussed.
You think that's a management decision that affected the overall financial condition of the company?
I don't know really all the parameters that those were made under. I wasn't in this role at that time, so.
What about declaring full and increasing dividends until July of 2018?
So dividends do have an impact, positively and negatively. Our decision to cut the dividend had an impact as well. But yes, those would have an impact.
Cash out the door, right, would affect the financial condition.
That's correct.
And how about now? I mean, even after July, we're continuing to pay millions of dollars in dividends every quarter.
Yeah, our dividend right now is being funded by the other parts of our business outside of the SC&G Electric.
Is that right?
It is. So it's being funded by our North Carolina subsidiary, our Georgia subsidiary, our gas business here in South Carolina, but not our electric business.
What about the management decision to remove $110 million from its accounts this year and to put into the to secure senior management's merger-related compensation?
Right. Those funds go to folks other than just senior management, but that decision was made in January because of the merger.
But taking $110 million in cash out of the company's accounts and tying it up in a revocable trust, that has an impact on the financial condition of the company, doesn't it?
It does. But that trust is subject to the claims of bankruptcy and is irrevocable after the closing of the merger.
Is it that money's not available for operations?
Not today, no.
What about paying hundreds of thousands of dollars a year to a retired CEO for no work and charging that to customers?
Yeah, I don't have the specifics around that contractual arrangement with Mr. Timmerman.
But that would affect the overall, it's a management decision that affects the overall financial condition of the company, right?
That would be an expenditure that affected us, yes.
What about if y'all were to, for example, pay senior management, and by senior management in this example, I'm just talking about the top 4 folks, Marsh, Byrne, Addison, and Archie. Okay, just those 4. If in the last 2 years of the project, 16 and 17, let's just say, for example, you paid those guys $25 million, that'd be a management decision, wouldn't it, that would affect the financial health of the company?
It would be a decision that would affect the financial health. I think not to quibble with you, but I think our bonus decisions are made by the board and not management, but certainly it would impact our financial health.
Either board or management decisions. These would definitely affect the company. Paying bonuses for the project and charging those to customers, that impacted the financial health, particularly if it's not recoverable.
Correct. Yeah.
How about the management decision not to sell the North Carolina gas business for more than $2 billion? Was that a management decision that affects the overall health of the company?
Yeah, that is a management decision, a strategic decision that's made by management and the board.
And we heard about it this morning. Apparently, we're not going to learn what it is, but we know it's at least tens of millions of dollars that are being spent fighting this litigation, and to support the claims of privilege and confidentiality that have been part of this litigation. That would have a material impact on the financial condition of the company, wouldn't it?
It would have a material impact, yes, on the financial condition of SCANA overall.
And what about reassessing, with the accuracy of hindsight, let's say in May 2017, whether the conditions favored nuclear construction in 2008, and whether that idea that nuclear power was the right decision, whether that changed sometime in 2014 timeframe. We've heard some testimony about that, right?
We have heard testimony about that.
And SC&G did analysis, right, during that period of time about what the cost would be for abandonment, and we'll hear from Dr. Lynch, but that was ultimately a management decision, right, that affected the financial health of the company.
Are you speaking about the decision to stop the project?
Well, back in 2014, it was actually a decision not to stop the project at that point.
Right. Yeah, I couldn't speak to that in 2014.
Instead of just continuing to spend on the project another more than $1 billion, but that was a management decision at the time, right, that affects the financial health of the company today.
Yeah, the decisions made by management to continue the project in 2014, yes.
And so, and there probably, and maybe others, those are just the ones I came up with, but despite those management decisions that obviously have an impact on the financial health of the company, SC&G is actually asking the Commission to give it a higher rate of return, in part because of these management failures, rather than a just and reasonable rate based on a proxy of investment grade, utilities, right? Isn't that right?
I don't think I'd agree with you on that. I mean, the proposals that we've put forth, as we showed, when we calculate those in total with the business, we're well under the 10.25% return that we've mentioned.
Yeah, we'll talk about those calculations, but SC&G and Dominion are here asking the Commission to provide it with a guaranteed return on equity of 10.25%, except in the alternative plan, in which it's 9.9, right?
Well, that's right, but we're also proposing to write off billions of dollars of assets as well. So we're not asking for 10.25 on the entire investment in the project.
Right, just the prudently incurred costs, right?
Well, just the amount that we're not asking shareholders to pay for through the write-offs.
And even at the ORS rate of return on equity of 9.1%, that provides a guaranteed profit for 20 years on the allowed N&D cost, isn't it?
Well, the authorized ROEs that the commission gives us are never guaranteed. They're they're sort of a cap, if you will, so we can earn up to that amount, but it's not a guarantee.
You're allowed to figure that into the rates that you're charging customers, right?
That's right. But if you look at even our base business, I mean, we're allowed an ROE of 10.25 there, but we're earning much less than that.
So you're really saying y'all want even more than you're asking the commission to give you?
No, we're not. We're asking for resolution to this issue.
And even when you get this these returns on equity, they're guaranteed returns on equity, that comes into play after all the debt payments have been made, isn't that right?
Well, the equity return, yes, is just applied to the equity portion of our business.
Is it fair to say that these management decisions that we just went through have had a far greater effect on SC&G's overall financial condition than the experimental rate of $78 million a year that SC&G is collecting? No,
I don't think I would agree with you there.
Some of them are much greater issues than just the $445 million in revised rates. Isn't that right?
Some of them are greater dollar amounts, yes.
It makes them more material, right? It's more significant to the company's overall financial condition, doesn't it?
Right, but I mean, some of the things that you mentioned, like the decision made in 2014 to go forward with the project, certainly that had greater monetary consequences, but that was a decision that was made at the time based on the information that was available by management, as opposed to the nearer term or more recent impacts that have happened related to the uncertainty of recovery of the nuclear costs.
You know, it seems like to me that that there, particularly the economic witnesses in this case, that SC&G is here asking for the commission to bail out these mismanagement decisions, to overcome these management issues, and to just focus on the NND cost recovery, kind of to save the company. Is that?
I would not characterize it that way. I think the proposals that we put forth, particularly the proposals that Dominion has put forth, provide a balancing of interests between shareholders and customers.
Well, let's did you end up overseeing the internal investigation in the CompuWorld kind of bid rigging scandal?
I did.
I mean, that was a situation where there were literally false invoices that were being submitted and paid?
It wasn't really false invoices. We had a complaint from one of our auditors on the site that they had noticed some irregular spending and started diving into it more. And as we looked, we found that there was one procurement agent that worked for the consortium that was getting bids from CompuWorld regularly. And the requirement was that those bids would be, if they're over a certain dollar amounts, they should receive competitive bids for the project. This procurement agent was reaching out to this one CompuWorld, and CompuWorld would then submit a bid for himself and 2 other companies, which virtually always guaranteed that CompuWorld won the business.
It was self-dealing, though. It was an inside job, wasn't it, for the supplier, the vendor?
Yeah, for the vendor. We never were able to demonstrate that the procurement agent actually was benefiting from it at all, other than avoiding some additional work. He was taking an easy path out, but we never were able to demonstrate that he received any kind of monetary gain from that. So it was really to the benefit of CompuWorld.
There's no doubt fraud on the project, right?
Bid rigging is considered a type of fraud, yes.
Y'all didn't go to law enforcement about that, did you?
We did not. We did have our corporate security group involved in that, and they have ex-law enforcement agents there on that team, but we did not go outside to law enforcement.
That's another management issue, isn't it, that affects overall financial health of the company?
In that case, yes, but we were able to resolve that as part of the broader solution when we signed the EPC contract. So we brought that to the attention of Westinghouse and the consortium, and requested that that individual be removed from our site and that we not pay for the amount that had been spent with CompuWorld, which I think was around $1 million.
So, just to be clear, SC&G is not asking the commission to set an NND cost recovery for the next 20 or 50 years to make up for poor management decisions that are straining the utility. Isn't that right?
We're asking for the commission to approve one of the proposals that's been put forth that will bring some resolution to this issue for the company and for our customers.
And in the same vein, you're not asking them to look at unrelated rates issues that might be causing financial strain on the company in setting the NND cost recovery, are you?
We're not asking for a base rate change.
Other than the CompuWorld investigation, which you helped oversee, did you have any direct involvement in the prudency issues for this project?
I did not.
Like Carlette Walker's testimony in March or 2015, were you involved in that at all?
I was not.
Did you, what about the Bechtel assessment report or the project assessment report? Were you involved in that?
No, I was not involved in those either.
I think we've been through most of those. How about the 2017 estimate to completion about the additional years and the $2.5 billion in additional costs that it would require?
Yes, I was involved in that.
What about the fixed price option and whether Westinghouse could shoulder those additional billions of dollars under the fixed price?
I was not involved in negotiating the fixed price option.
And the analysis and decision to abandon the project, were you involved in that?
I was. Yeah, sorry. When you were talking about the ETC, those things I connect in my mind, but yeah.
Because it made the decision obvious at that point, what the additional time and cost.
Yes, the additional time and cost and the lack of a partner meant that there was no chance for us to continue.
Did you know at that time or before that Westinghouse's exposure to the VC Sumner and Vogel plants, not completing those, could have exposed it to liability in excess of both it and its parent company's total market capitalization?
No, I did not know that at the time.
At
the time Westinghouse filed bankruptcy, no, we didn't know that.
But you've heard that through Mr. Elliott's questionings, right?
I did hear that.
And you don't have any reason to disagree with that?
No, I don't. I think, when we evaluated it, we were looking at the amount to go and understanding that we had the Toshiba guarantee. So that really meant that Toshiba was going to provide us that amount of money in terms of compensation or damages, not that we were going to go back and ask them for everything we had spent on the project. But that was just my understanding of the situation.
And the Toshiba guarantee was about $2 billion.
That's right.
We're talking about exposure in excess of $12 billion, right?
If you were to add up the total cost that it would have taken to complete the projects, yes.
SC&G is not seeking to recover any NND costs incurred after abandonment, are they?
We're not seeking recovery of any cost after September 30th, 2017.
That's in a wind down phase.
That's right.
But nothing that's been incurred after that date.
That's correct.
Let's talk about the zone of reasonableness that was mentioned earlier today here. You agree that that in determining any adjustment to the experimental rate that the parties and the commission were directed to set the lowest possible rate within the zone of reasonableness? Were you familiar with that?
I don't know that I was familiar with those exact words, but generally I was familiar with the idea, yes.
Okay. And then the last sentence of that section says, nothing herein prevents the commission from adopting as its own rate the experimental rate directed by the General Assembly. Do you see that?
I do.
And you knew that when y'all filed the petition, didn't you? When you started the hearing and filed your pre-file testimony?
Yes.
So the commission could actually decide that the allowable cost recovery is $78 million annually, right? That's the experimental rate cost recovery.
That's right.
And are you familiar? You've analyzed and testified about the ORS plan. ORS is actually recommending that the company get $86 million a year in NND cost recovery. Isn't that right?
That's correct to a point, but I think comparing those two numbers is a little bit of an apples and oranges comparison because the experimental rate just provides for a return on the investment, so it does not include amortization, whereas the ORS plan, there's about $45 million of amortization expense in that, so really you're looking at a net number of about $41 million under the ORS plan versus the $78 million that's under Act 258.
And in fact, the SC&G base rate case says just continue the revised rates, right, and convert it, the same number, into an amortization of all the costs, right?
Under our base request, I think we plan to amortize that cost over 50 years, I believe.
But your plan, as described in the testimony, is actually just to take the revised rate, which is the financing cost, and continue it, but consider it an amortization of all the underlying costs as well, right? That's
right. We were going to be reducing our return on equity, if you will, to cover the amortization expense under the base plan.
So you could compare the ORS plan and the experimental rate plan using the same logic that SC&G is using and say we're going to take these, what were financing costs, and just convert it into the amortization of the other costs, just like ORS did, couldn't you?
You could certainly do that. I think you've done it in all the other plans except Act 258. I think Act 258 just was meant to be temporary and didn't include recovery of the amount spent. So it didn't include any amortization expense.
And the real difference between the experimental rate and the ORS plan is the Tax Cut Jobs Act savings, isn't it?
Well, I think, like we talked about, the plans that have been put forth mostly deal with just the new nuclear recovery, and then there's the Tax Cuts and Jobs Act money that needs to be given back to customers as well.
And no doubt that the experimental rate does not include the Tax Cut Jobs Act savings.
I wouldn't want to say that with 100% confidence. I could agree with you that I don't think it does, but I haven't analyzed it in detail.
And one of the problems that you have a little hesitancy is because even though there are savings being realized by the company from the Tax Cut Jobs Act, you're actually just holding it in a deferral account, right?
That's right, pending the decision here by the commission in terms of how do we need to give that back to customers.
And so,
but I would say we have every intention of giving that money back to customers.
And so because of that, you know you're not passing any savings from the Tax Cut Jobs Act to customers at this point, don't you?
That's correct. We're waiting on that rate to be set here at the commission.
And the experimental rate is actually the rate that has been in effect at least since August.
That's right. I believe it was retroactive to April.
Okay. So we know that the experimental rate does not include any of the savings from the Tax Cut Jobs Act.
I think that's fair.
Okay.
I can agree with that. But it also doesn't include amortization expense either. So.
But the ORS plan does.
Yes.
Of all the allowable costs through March 12, 2015.
I think that's the case.
And nothing in the law that you know of requires the commission to permit SC&G to recover more than the experimental rate in the NND costs, do you?
I'm sorry, could you repeat that one?
You don't know anything.
Objection, Mr. Chairman, again, that calls for a legal conclusion.
Okay, we're going to let her try to explain that.
Thank you, Your Honor. And it'll be a little simpler when we go to her testimony in a second and we see all the legal conclusions that are in there. But let's just
overrule that and we'll let her explain.
If you can. Do you know of any reason why the commission can't accept the experimental rate as an amortization of all the NND costs?
No, I think the commission has ultimate authority on the rate that's set.
All right, let's go ahead and look at your testimony now. Did you write any of your testimony?
I did write portions of it. Whenever we draft our testimony, I met with our attorneys and my team And we covered the topics that needed to be included, and then they provided me with a draft that I edit extensively before I file it.
In early August, the first direct testimony that you filed, you hadn't even seen a version of you haven't even seen that, had you? 3 days before it was filed.
No, I had seen it. I had not seen a final version. It was still being edited that weekend before federal court.
You were waiting for other people to give that testimony to you to review.
No, I had already read it and given extensive feedback to it, but it still wasn't final.
Let's look at your testimony, rebuttal testimony on page 4, lines 1 to 3. Right there at the top, right? This is in one of the aspects of setting the permanent rate that you testified about. You say, can you blow it up so we can read it? I'll read it in the meantime. Allow SC&G to recognize its statutorily mandated cost of capital on the unamortized balance of the asset subject to voluntary. What is the statutorily mandated cost of capital for the abandoned N&D costs?
I think my interpretation of that is it's the 10.25% ROE that we have been authorized under the Base Load Review Act.
Okay, so that was under the revised rates orders when the project was being constructed, right?
That's right. That's the only point of reference we have right now.
You're not saying that's statutorily mandated for this proceeding or the future N&D cost recovery?
That's right. I think that's up to the commission to decide.
Let's go to page 6 of your rebuttal testimony. At the end of the paragraph there's the final line of that first paragraph. It talks about that the current utility expenses and costs of capital fully justify pre-Act 258 rates. That's the whole $445 million in revised rates, right?
That's correct.
That's full recovery of all N&D costs, right?
That would be correct. Well, that would be correct. There have been costs that have been spent since our last revised rates proceeding. I think Ms. Nagy referred to those that we have not asked for recovery for.
So really up through September 30th of 2017? I
think it actually goes prior to that because we did not have a revised rate filing in 2017. So it actually goes back maybe a year or so before that.
So in this statement, you're actually referring to just all of the costs through the last revised rate filing?
Yeah, I think what we're saying here is the 445 is justified.
Mm-hmm. And do you really believe that SC&G is entitled to the full revised rates going forward?
I think the proposals we put forth here create more of a sharing of responsibility between shareholders and customers. But we do feel like the 445 was set based on information that was known at the time and reviewed at the time.
On page 12 of your testimony, there's an interesting first full paragraph there. It starts with however, second sentence of that first full paragraph. SCE&G rejects the suggestion that anything other than its actual cost of capital should be used in setting rates. In the next sentence, SCE&G's cost of capital is an objective number. And the next sentence goes on, to limit the cost of capital to a level that is less than the actual cost violates SCE&G's right to a just and reasonable return for its investment. Does that mean that SCE&G is telling the Commission there's only one objective number, the actual cost of capital that can be used for a return, just and reasonable rate under N&D cost recovery?
No, but I think what we're talking about here, ORS's proposal put forth that we should consider a cost of capital that looked at an investment grade companies. And if the ORS proposal is put into place, we feel like we would not be an investment grade rated company, so we would have a higher cost of capital than those companies. So to set rates basically at a level where you know the company is not able to attain those rates would create an automatic shortfall that would cause financial harm to the utility.
So, your summary, you said pretty clearly that the financial metrics right now are investment grade.
They are.
And here you're saying that the cost of capital is an objective number. It's the actual cost of capital. And so it sounds like to me that you're asking for us to assume what it might be if it weren't a investment grade and then set the cost of capital at that other number.
No, the metrics are investment grade. The ratings are separate from the metrics and include qualitative factors as well. So the metrics are investment grade currently, but we're already rated below investment grade by one of the agencies. And if the ORS plan is put into place, then we would have metrics that were actually below investment grade, in addition to the qualitative factors that are viewed negatively. So we would likely be below investment grade at more than one agency. And therefore, I don't think it would make sense to compare us or to pretend that we were an investment grade rated company and able to obtain capital on those terms, because we would not be able to.
But you are now, right? You're able to obtain investment grade cost of capital right now, aren't you?
No, we're paying higher cost of capital than our peers that are investment grade.
That's the table 1 in your testimony. That we'll look at it in a second. We'll come back to that. Let's just keep going, because I just want to go through a few more highlights of this rebuttal testimony. On page 15, you talk about incentive compensation payments or at-risk compensation. You're just talking about bonuses, right?
That's right.
And did you hear Mr. Addison say, I believe yesterday, that he would agree to remove all bonuses from the project and not charge ratepayers any more than they've already had to pay for bonuses?
I did hear that.
And do you agree that that's just and reasonable?
I think that would be a decision that the commission could reasonably make.
And then on page 17 of your rebuttal testimony, you these are those these calculations you've been talking about that you claim to have calculated the anticipated financial results if the ORS plan were to be implemented. But you know that ORS is actually suggesting SC&G gets more for N&D cost recovery than the experimental rate, right?
On a gross basis, that's correct. But as we talked about, that doesn't include the amortization expense.
And you used in this analysis, you used an adjusted test period of 2017, and what SC&G would have earned a return on equity lower than its allowed return on equity of 10.25, which was set in 2012.
That's correct.
And further decreased in 2016. Why did you set up a new test year when you had a test year for the last rate case?
Well, we looked at December 31st, 2017. We initially started preparing these filings around January after the merger was announced. So the December 31st, 2017 was the most recent period that we had at that time.
But it's not a test year, is it?
We used a 12 months ended period, and then we did our standard pro forma adjustments that we would do like when we file our quarterly filings with the commission. So we take the historical results and then put known and measurable pro forma adjustments on top of that.
And so, assuming that this exercise is accurate or has any value, this is what your conclusion is, right? That you want the commission to award SCANA shareholders and management another $100 million a year in revenue. Isn't that what it says?
No, that's not. That is simply saying that even under this plan, it would take another $100 million to get us back to the 10.25. So even under this plan, under the ORS plan, we would be significantly under earning our allowed ROE.
And based on the same kind of exercise, you found the same was true under earning the return on equity in every plan in this entire case, right?
I believe that is correct, yes.
Right. Doesn't make it very helpful, does it?
Well, I think it goes to the severity of the under earning. that varies throughout the different plans.
All right. Well, and your calculation here for the ORS plan, that's over 7.5% of profit for shareholders after all the debt payments have been fully paid. Isn't that right?
That's correct, but you have to compare that to what our utility peers are earning, because that's what the market would do when they're trying to decide where to put their money.
All right. Well, let's get to table 1 on this is page 9 of your direct testimony, and we'll see about the peers and how you're faring with the peers on the issuing debt. This is in dockets 207 through 305, page 9. You included a table 1, and it shows some other utilities issuing in August, first 2 weeks of August. And you show August 15th, SC&G had an issuance and got 4.25% interest rate, right?
That's right, on a 10-year debt.
And the comparisons show a spread of approximately 80 basis points above the Treasury rate.
That's right.
For the others.
Mm-hmm.
And for this issuance, 143 basis points.
That's right.
But didn't you leave out one of the issuances, bond issuances for SC&G?
Well, we had a 10-year issuance and a 3-year issuance. So this is the 10-year issuance. Most utilities are not issuing 3-year debt right now because interest rates are so low, so they're preferring to issue longer-term debt. We were not in a position where we could really do that and attract interest. So we don't have a lot of other utilities during this time period that were issuing 3-year debt to compare it to. So that's why we compared the 10-year debt.
Yeah, but you left it out. And what was the interest rate on the other issuance of debt?
I believe that was 3.25%.
And that would be what, more than 75 basis points lower, making the spread less than 70 basis points from the Treasury rate, and the lowest one on this table?
Right, but these are 10-year debts. You pay a higher spread for the longer term because there's more risk with that. So I don't think you could compare the 3-year rate with the rates on table 1.
Right. But it does represent the 3.5, not 3.25, but the 3.5 interest rate that you got on the same day for a couple $100,000 in debt borrowing. Is the actual cost of debt in August for SC&G, wasn't it?
That is correct.
Okay. And it was better than all of the ones on this table that you put in your testimony, wasn't it?
The 3-year debt, you can't compare it to table 1. To answer your question specifically, yes, the rates are lower, but it's because it's 3-year debt, not because it's comparable to the numbers that are shown there in that table.
Mm-hmm. Those dollars spend the same, though, don't they?
Well, yes, they do.
In your direct testimony, pre-filed testimony on page 38, you first say at the top, let's go, if you can, page 38 of the direct pre-filed testimony, you first say that returns computed net of these impairments are inflated. I think this is the explanation of the exercise on computing these different rates of return. And then second, you said, if recognized for rate-making purposes, the impairments entail a full loss of invested capital equal to the amount of impairment, and that this loss translates into a one-time loss of earnings in the amount of impairment in the year of write-off, and a permanent return on equity of 0 of that going forward, right?
That's correct.
So what you're basically saying is that I want, with the disallowed cost, I want to use those to show that our return on equity is really a lot less than what we were authorized. I mean, isn't this your basic assumption?
No.
That you are using the disallowed cost to try and illustrate that you're not getting a full recovery?
I think what we've done is really the opposite. So we have removed the revenue that would be attributable to the rate reductions under each of these plans, but we have we've left the cap structure assuming that there's no impairment. We have also removed the rate base as well. So what we're saying is we're assuming that, in some other proposals than $2 billion of an impairment. We're saying that $2 billion we're going to earn 0% on, and we're going to remove it out of rate base altogether. So really what's left is what we're earning a return on.
So really, there's three things going on there, right? One is you're removing the revenues because you're not allowed to recover on disallowed costs, right? So that's
right.
That's not really an assumption to be made, is it? That's just a fact.
Well, it is a fact, but it varies depending on the plan that you're looking at.
Right. And then the second thing you've got going on here is that you're suggesting that the disallowed costs should somehow continue to be included as if it were prudently incurred. That you should consider not getting a return on that as being somehow unjustified.
No, I think this is where it's a little different than what we talked about in federal court. In federal court, we did assume that if you left that rate base in place, but you removed the revenue, and then we calculated what that return was. What we've done in these cases before the commission is we have said we're going to remove the revenue and we're going to remove that rate base that we're impairing, and then we're just looking at what rate base remains and what are we earning on that rate base. So anything that we are impairing or writing off, we've removed from these calculations.
Mr. Richardson.
Yes, sir.
My watch just told me it was time to stand up, so we're going to take a 10-minute break.
Thank you very much.